Welcome to the Explainer. We're diving into a really interesting Supreme Court case today. It's basically a showdown between a beachfront resort and a bunch of local food stalls. You've got this classic conflict, right? Property rights on one side, people's livelihood on the other. And the final decision here? It set a huge precedent.
So, what exactly happens when your neighbor's business on a public beach starts becoming a public hazard? Well, today's explainer gets right into the legal battle that answers that question. And at the heart of it all, you have the Villa Alexandria Beach Resort, the Calimlim family, and this really critical legal idea called a nuisance.
Okay, so here's our game plan. We're going to start with the dispute right there on the shoreline, look at the big legal question, follow the case's journey through the courts, break down the Supreme Court's verdict, nail down the final legal principle, and then wrap up with the aftermath and what it all means. All right, Section 1, a dispute on the shoreline. Let's dig into the facts of the case and get a clear picture of what was going on. So you've got two sides to the story. On one hand, you have the spouses Goño, who own the Villa Alexandria Resort. They're saying, hey, our guests are complaining. These stalls next door are loud, they smell bad, the view is blocked, and their toilets are leaking into our dining area. They even pointed to an open-fire kitchen as a major fire hazard. But then you have the Calimlim family. Their defense? They're like, we've been here for over 50 years. There are other stalls just like ours on this beach, and if the resort is losing money, that's just business competition. It has nothing to do with us. And when we talk about operations, we're not just talking about one little food cart. This was the whole shebang. We're talking informal rest houses, video key machines blaring, billiard tables, little sari-sari stores, and small eateries, all with these makeshift open-fire kitchens. It was a whole cluster of activity right there on the beach. Okay, so that brings us to the core legal question. The entire case really hinges on this one idea. What is a nuisance? And more importantly, did the Calimlim stalls actually fit that legal definition? So let's look at the law. Article 694 of the Civil Code gives us a pretty clear definition. A nuisance isn't just something that gets on your nerves. Legally speaking, it's any act or business that injures or endangers the health or safety of other people. Or it could be something that annoys or offends the senses. Or it could just be something that gets in the way of you using your own property. Now it gets even more specific. There are actually two types of nuisance. A public nuisance affects a whole community or a bunch of people, maybe because it's on public property. A private nuisance, on the other hand, is much smaller scale. It's something that just violates the rights of one or a few people. And trust me, figuring out which one this was, it turned out to be absolutely crucial. All right, let's move on to the journey this case took through the court system. And believe me, it was a journey, with some serious twists and turns in the lower courts. So check out this timeline. The Goños filed their complaint way back in January 2012. It takes until November 2020, that's almost 9 years, for the regional trial court to make a decision. And what do? They dismiss the case, siding with the Calimlims. But then fast forward to 2023, and the Court of Appeals comes in and completely reverses that decision. And finally, in 2025, the Supreme Court weighs in to settle it once and for all. Yeah, so at first, the trial court basically said, look, the harm here isn't substantial enough. They kind of saw it as just normal business competition. You know, you've got a busy beach, you're going to have stalls, you're going to have resorts. It's just the cost of doing business. So they dismissed the case. But then, whoa, the Court of Appeals takes a look and has a totally different take. They said, hold on a second. This isn't about business competition. This is about illegal structures built on public property. And because it was on public land, they classified it as a public nuisance. That changed everything. So now you've got a legal standoff. The trial court says one thing, the Court of Appeals says the exact opposite. That means it's time for the Supreme Court to step in and deliver the final verdict. Let's get into their reasoning, the ratio decidendi. That's the core legal principle that drove their decision. The Supreme Court really just focused on the cold, hard facts that nobody was disputing. Fact 1, the structures were built on public land. Fact 2, the Calimlims had actually applied for a lease from the DNR, but they were denied. So fact 3, they had zero legal authority to be there. And fact 4, their operations, the open kitchens, the unsanitary conditions, were a hazard. Oh, and they didn't have any permits either. It was a pretty clear-cut picture. And this is where it all came together. The specific type of land was foreshore land. Now, what is that? It's basically that part of the shore that's covered and uncovered by the tide. You can use it, but you have to lease it from the DNR. The Calimlims didn't have that lease. So that whole we've been here for 50 years argument,
Legally, it just didn't hold water.
Okay, so what can we learn from all this? The court's verdict gives us a really important legal principle, a doctrine that goes way beyond just this one case on this one beach.
The court didn't just call it a nuisance, they used a much stronger term, nuisance per se. Think of it like this. Some things are a nuisance only under certain circumstances, but a nuisance per se is something that is a nuisance by its very definition. It's a direct threat to public health or safety. There's no gray area.
And they didn't just pull this out of thin air. They pointed to an older case, Sichon v. Aquino, which basically said that if you build houses or structures on public streets or waterways without permission, well, that's not just a public nuisance, it's a nuisance per se. End of story. So, here it is, the big takeaway, the legal doctrine from this case. If you build something without permission on public foreshore land, and that structure endangers public safety, it is a public nuisance and a nuisance per se. It's a double whammy, legally speaking. So, where did that leave everyone? Let's get to the final section, the aftermath, what the court actually ordered, and what it all means. The court's final order, the disposition, was crystal clear, no wiggle room. They ordered the Calimlims to demolish all the illegal structures, get off the premises, and, on top of that, pay damages and attorney's fees to the Goños. And let's look at those damages. They awarded $10,000 in temperate damages for the resort's financial losses, another $10,000 in moral damages for all the stress and aggravation, and a final $10,000 in exemplary damages, which is basically the court making an example of them to discourage others. Add in the attorney's fees, and it was a significant financial hit. And this whole case really leaves us with a big, thought-provoking question, doesn't it? How do we, as a society, balance an individual's need to make a living with the public's right to safely use and enjoy public spaces? It's this constant balancing act. There are no easy answers, but this case for sure gives us a lot to think about. Thanks for tuning into this explainer.